Hello, everybody. Welcome to the latest episode of RallyCast. Really happy to have you all. I hope everyone was having a good winter. It's very cold here in London, as you can tell. But joined, as always, by Carl. And this week we are really excited with our very special guest, Alessandro Cossu, joining us from Milan, I believe.
Well, actually, I'm in Bologna at the moment.
Nice.
Which is better than Milan. Well, it depends on your taste, but I'm in Bologna at the moment, and it's quite cold here as well.
And Carl, I think it was like raining for 2 days, so LA is shut down, isn't it?
I was going to say, normally I'd say, hey, welcome to the RallyCast from sunny LA, but we've had some precipitation. It hasn't really started yet here today, but it's supposed to be for the next couple of days, and everything shuts down here. Nothing happens in LA except for the RallyCast. So we're here.
Only thing that stops us is losing your voice, but that's not going to happen today. But a little bit about Ale. He's been just great chatting with him, getting to know him over the past year. But I'll let him kind of say a little bit about his background and set the scene for this week's topic.
Yeah, I can say a few words. I'm currently working as a patent attorney for an Italian patent law firm. I essentially do litigation within the company, which means opposition and appeal proceedings before the European Patent Office, where I used to work. I was a patent examiner. I spent 15 years there. I also worked as a trainer of new examiners and experienced examiners when I was at the office. And then at some stage, I decided to change sides, so to say. I was fed up with examining application, and I decided to start writing application, drafting applications. But most of all, as I said, I'm involved in litigation. And this means also that I do a lot of, quite a good share of search, prior art search. So I play around with tools for performance search. But the part of the job that I like the most is, as I said, litigating. I'm a very nice person, and I'm not inclined to litigate generally, but I have to say that litigating patents in court, for example, before the United Patent Court or before the EPO makes fun, it's very interesting, challenging. And apart from that, I also advise clients on IP matters in general. That's my background, and I am a microwave engineer, but nowadays I do very little in the field of microwaves, and I think I see more mechanical stuff and things like that. That's essentially my background.
Yeah, and I think it's an exciting take that we're going to be going down this week in this episode. And we've been talking about the impact of AI with patents and IP when it comes to prior art searching, when it comes to decision making, when it comes to even trying to take a time machine and going back. But I think it's really interesting to have your point of view on the impact of AI on the litigation aspect. So hopefully for today, we can knock down a few topics and come up with some pretty interesting ideas. And as always, the topic of today is imagine if. So I guess we can kind of start with imagine if, and I'll put it to you, Ale. When it comes to litigation, and everyone's fear, let's say, is that AI is going to take over the robots. But I want to hear from you kind of what your maybe more ambitious imagine if would be in the sense of AI in litigation.
Yeah, I think, thank you very much for asking the question, because I think I would say, as with the majority, or I would say with all the innovations in the history of technology and science, there is generally at the beginning a tendency to resist the change and to see change as negative or as bringing disasters and generally taking away jobs or producing. But I think that this is at least my view and my attitude toward change and innovations. I think that you have to embrace everything that's change or innovation, but you have to look at, I would say, at the positive aspects of what innovation can bring. And I think that AI in litigation can be a game changer. But the point that I would like to stress, and I think that this is what I would convey as a message to anyone who's listening, is that in litigation, it's still the patent attorney, the humans, who are in charge of the whole process, and only those who will be able, so to say, to make the best use of AI will be able to take the most out of it. And honestly, I don't think that AI is going to be, I would say, to bring disasters. The crucial point is that you should be able, and I'm pretty optimistic on this, to take control of the whole process, to keep control, I would say. And I don't think that AI is going to have a negative impact. There is a lot of talk about, for example, hallucinations. You probably heard about that, because sometimes attorneys, I would say dishonest attorneys, or people who are not taking their responsibilities seriously, decide to use AI to draft quickly or more quickly, for example, documents or legal submissions by using AI. But in the end, and this is what you experience, you can experience, you see that these attempts to use AI simply to cut costs, they fire back. You get caught by judges, and in the end, this is leading nowhere. Whereas people who are able to exploit AI in a clever way, and maybe we can discuss what I mean by that, can really, let's say, have a gain, have an advantage over competitors, or in general in litigation. This is my take. So I don't think that you have to say, as some people say, you have to embrace AI without thinking critically about it. But I think that it's a great opportunity. This is my.
Well, one thing that comes to mind, and I think that's totally valid, is it's interesting now there's like this, there's almost like, even if you want to try to use it responsibly, right, to augment the way that you're adding value, and you're doing it in a way that is thought out and like pragmatic, there's kind of a multitude of different types of models and different types of tools out there where you actually have to understand what that AI model is being built on. And you talked about hallucination, and where does that come into play, and how is the model actually being put forth and built. And I think that introduces, it does introduce some risk as well. So I think it highlights the importance of not only thinking about it being an augmentation, but thinking about, what type of tool am I using? Where is this information coming from? How does this come into play with how I'm trying to use it? And I think that there's more of a burden now on those out there, in the industry in general, and just, overall, to kind of sift through that and make sure that they're, using something that's, trusted. Right. And I think that has created this kind of, okay, well, verify but trust type mentality, trust but verify, mentality when thinking about how to use it. So
if I may just jump on that, that's absolutely correct. But if you think of it, that means that you have to take more responsibility, because, as you said, now you have to critically review the output, for example, of AI. You have to understand how these AI models work in order to be able to take the most out of it and to avoid, for example, falling into some pitfalls and traps that we already have seen. It's not just about hallucinations, but in general, you have to understand what you're using. And this means that those who are going, in my opinion, to benefit most from AI are those who are going to understand how these models work, and then they will make the most out of it. But this means that you really have to take responsibility, and that you have to deepen your understanding of these tools. But once you understand those tools and know that they can provide you with an edge, with an advantage, then I think you can really, in front seat, you can really lead, I would say, because you're going to make the most out of it. And it's not just about time. It's not just about coming quickly to a legal appraisal, because in the end, I think this is important to understand. It's the human, it's the attorney who's going to make this appraisal. You can't think of blindly trusting the output of AI, no matter how good it is, no matter how well you understand AI. There will always be a contribution from the human side. But if you want to do this not only responsibly, but in an efficient way, then you have to understand what you're using and what, as you said, the models do. Because once you understand that, then I think you will be able to make the most out of it. So I don't want to downplay the ethical aspects of it, because I'm really conscious, and I think everyone who is working in the field of litigation understands that if you do litigation, you have to be very honest, you have to take your responsibilities, but it's also a matter of efficiency. If you want to be good, you need to understand the models, you need to know how they work, and you have to do a good deal of work. You have to sift through the results to check whether these results are, for example, legally sound, whether they are relying on real cases, whether the I would say legal aspect, the I would say the consistency with the case law, for example, is ensured. You can't simply say, oh, this AI model, I'd say ChatGPT says this, then I'll take it. No, you still have to have a deep knowledge of case law to understand how, for example, a judge will react to an argument, or to understand whether an argument is solid. And this requires, I would say, more involvement from the human side than before, in a way.
It's like the famous case of the contract in Australia. I'm not going to name the company that sent out a contract written up by AI, didn't check it, and found out that it was all just a bunch of bogus. And just what I've seen is, once you go into that courtroom, it's you, the facts, and a human. AI is a good augmenter in the sense of, and we talked about this before, Ale, you have the massive firms that have the foot soldiers that are able to do the research and do the confirmation. Then you have the smaller firms that may rely on AI for that research, but you still need to understand what is in that content. I think the analogy I always think of is, if you have the same ingredients as, say, to make chocolate chip cookies, than a store-bought brand, and you're making it at home, you're breaking the eggs, you're mixing it through, you're getting the clumps out, throwing it in the oven, and in the end, you have two of the same exact cookies. The one that you made is going to taste better. But if somebody walks in and says, how was the store-made cookie made? You'd be like, oh, these are the ingredients, but you don't know the process. So it really is, I think, ethics is a big thing, but I think if ethics are your second or third, importance, you're going to get caught up pretty quick. But what happens when we kind of stop baking together? And this is kind of something thinking about, the upcoming generation, the newer litigators, or the newer kind of attorneys or paralegals. What impact do you think having the right strategy with the AI and having the right mindset on their side will have on the future litigators?
Well, I could see two areas where there can be, let's say, a change and an improvement. Well, the first, obviously, is time. I think everybody's conscious that if you use AI, and when I say use AI, I mean use it responsibly and consciously, knowing what you're doing, what the models are, as Carl said, then this could lead, obviously, to a save time. It's, if you allow me, because I want to go back to your analogy with the soldiers. As you said, in the past, before AI arrived, anyone who is working litigation knows that a good lawyer, a good solicitor, has, I would say, an army of people working for him, doing the legal research, sometimes preparing also bits of the submission and so on. But in the end, it's the good litigator who has to review and put all the pieces together. So it's the analogy that you also use with the ingredients. And if you are a good litigator, in the sense you have good expertise and you understand how proceedings in court work, how judges react to arguments, how you have to present your arguments, because this is also a very important aspect of how you litigate. If you're good at, let's say, telling stories, because in the end, litigation is about telling stories and convincing your audience that you are right because your story is more compelling, more convincing. This means that if you have AI on your side and you have these results delivered to you more quickly, then the good litigator, who is already able to do this sifting through the facts, the legal analysis, and putting everything together to have a tasty cake, to use your analogy, then this obviously can be done more quickly. But I think that there is another aspect which is probably less understood. It's that, assuming, well, this is of course an aspect that we have to also to discuss, assuming that AI is working properly in the sense that hallucinations are not so frequent as sometimes happens, and assuming that you are good at sifting through the material that you get from AI, you can also, I would say, arrive at results that you would normally not arrive by doing legal research manually. I can give you an example. This is something that happened to me 2 days ago. I was discussing a case with some colleagues of mine. We were looking for case law, and we had identified some good judgments. But then a friend of mine used an AI model and asked the model a question about what we were discussing, and the AI model came up with a judgment that we hadn't found, which was actually very good. It was a real judgment, so it was not one of those hallucinations. And this means that AI can surprise you by drawing your attention to a case that you were not aware of or that you had not spotted, and all of a sudden you find yourself with a better argument or with a better judgment than the ones you had in mind that you knew. So it's a bit like, like the use of AI for in medicine for identifying, for diagnosing diseases. You know that because of the power of the computing power of AI, these tools sometimes can come up with a diagnosis that a physician might not be able to arrive at. Sometimes AI can surprise you, and this is the same. It's the same with litigation. What I have experienced with this case that I told you, this example, is that AI came up with a judgment that we were not aware of, and this was really. I would say a killer, because there were some passages which were really relevant, and we hadn't identified it. So it's not just about time saving. I think it can also be going more in depth, being able to achieve better results in terms of the quality of the legal reasoning and the, I would say, efficacy of your arguments, because you can find better results.
That's interesting. The mindset, because you would think that some, using the doctor or the GP example, some may be too proud to think that AI can do a better job than them, and they wouldn't even look for it. So there's also a risk in being so one dimensional with your view of it. Like your example is a very balanced view of using it.
To add to that, I
Yeah.
think the thing that I keep harking back to here is, and thinking about, is that you're bringing your own knowledge of what you do and your expertise into the scrutinization of that AI response.
Yes.
Because you've been there, because you have that knowledge and that experience. And I think that is something that is important to talk about in the fact that, if you think about back to JP's point of the kind of up and coming litigators in the future generation, and kind of what types of tools they're using right now to learn about how to, do their jobs and how to kind of exist in this profession. It's like you got to kind of, have a solid foundational understanding of what you're looking at in order to understand whether or not you've gotten a good result from the AI, and using that lens. I think that's something that, we've talked about this analogy about, using GPS, right? Like you kind of still need to know where you're driving. You can use the GPS to augment, your knowledge of the area, but it's like you can kind of understand the layout of what you're doing and where you are. I think that's something that needs to continue to happen, so that there's a human role in maintaining kind of a human-led, AI-assisted type mindset.
I fully agree with you, Carl. I think that what sometimes gets a bit out of the discussion and is not properly understood is that you still need to know where you're heading to. And the litigator, the good patent attorney, is there for that purpose. He must have a clear mindset. He must understand where he wants to go to. The AI, as you said, is a tool that can augment, that can improve your ability to see the landscape, to interpret the landscape, and to find your way toward the target. But you need to, the attorney must have a clear strategy. And personally, I'm not afraid of relying on AI in general, provided, as I said, that the attorney has a clear strategy and an idea where he wants to because, as you said, by going back to your analogy of the GPS, if you blindly rely on your GPS, you might find yourself driving into the water or into an alley that leads nowhere. And I don't want to end up like that. And I think that any good patent attorney, any good litigator is aware of that. Very much as I wouldn't rely blindly on what let's say, this army of soldiers doing legal research present me. I would scrutinize those results. I would go through those results, and I would do the same with AI. But I think that AI can be a great opportunity, provided you understand how it works and what advantages it can give you.
Right. And they're not even relying on it blindly. I mean, I think just being able to, look at it and take an approach of scrutinizing, and the more experience you have, I think, in my opinion, the better you're going to be at kind of interpreting things. Anyone who's listening that is a fan of The Office would understand why I'm smiling right now, thinking about a car driving into a lake.
Yeah. Well, Carl,
This is exactly
I'm
what
still
I know.
laughing at the fact that you said that you still use Waze to take your girls to school, even though you know
Did
the
I say
route,
Wade?
or Google Maps. But then you also know that maybe taking the side road is kind of the best way to go, and that brings me to Kathy Vidal's message that the winners are those who augment, not those who resist or outsource thinking. So you can't say no. I'm not going to use an app to tell me where to go, or I'm going to follow it blindly. You have to be flexible.
Flexible, and no, but I think this is the point, and I think this is actually something that marks any phase in history where there's been an innovation. You still need to be able to think critically. This is I think the essential point, which maybe this is something that we might discuss later on. Brings me also to the there is one aspect which I'm a bit afraid of, and when I think, for example, of my younger colleagues, I sometimes notice that they tend to use AI because they know that it's very they can it can help them get to the result very quickly. But sometimes they fail to understand that they need to learn how to do the work in a traditional way, to learn it the hard way, because unless you understand how litigation, for example, is done the traditional way, you might easily fall into traps. You might be tempted to rely on those results that AI is providing you, and in the end, you might even end up being unable to review those results critically because you have never been through the process of litigation, because you grow up, so to say, relying on AI, but without, for example, writing legal submissions or doing legal search. And this is, I think, the critical aspect. I think it's not specific to the introduction of AI. It's not just with AI. I think it's been the same with any innovation in the past. I mean, think of computers. You can use computers to do calculations, but you should not forget how to do simple math or do your compute integrals or whatever, do your calculus. But this is, I think, a point that needs to be, let's say, not to be forgotten. That to make the most out of technology, of any advancement, you still need to be able to know how things are done, how things work, how you do the math, how you compute something. Because otherwise, in the end, you end up relying on a machine, and you don't know whether the result is correct. You must be able to check that result. This is, I think, the only thing that I would be a bit concerned about when it
There's
comes to.
the risks, like we said, about the kind of foot soldiers, or kind of getting started out. And the view is, and I always say this even on a daily basis, that there's one thing that the marketers want you to see, and then there's the real world element. You see, like the news headline: X company cuts Y number of jobs, and AI is taking over the pedantic nature of it. But in the end, you also have to look at the human element of it. Is it cost cutting, or is it quality impact? And I think the quality and the cost is the human cost. If
Yes.
the roles are being sourced out to AI, then that's one paralegal who won't be gaining that experience of doing the research and then finding out it was an incorrect reference, or then
Yeah.
getting that hurrah when you come in and say we won the case based on the research you did. So at what point do we need to kind of move away from that AI is saving us money narrative to being AI as a quality amplifier? What do you see, Ale, in terms of the industry from these kind of the impact on that next generation? But more importantly, what should the decision makers be aware of that are listening to this call on the
Well,
impact of
yes.
going down the wrong path?
Well, I have to be honest. I think at the moment, most of the actors, most of the players are concentrating. I wouldn't say all, but most of them are concentrating on cost cutting. There is a certain risk, and I hear this argument being repeated that it's about saving costs. I think this is the wrong mindset, and I'm sure that in the medium long run, this is going to prove wrong. And I think that the players and the market will, so to say, correct this and go back to a more balanced attitude toward AI, which is AI as an enabler, as an augmenter, as something which allows you to provide better quality. I agree that this is going to be coupled to, I would say, cost saving, in the sense that you will be able to provide better quality more quickly at a lesser cost. But I think we should move away from this, I would say, rhetoric of AI as simply something which is there to cut costs, because this is the wrong attitude. And I think this is the same with any technological development. It's not specific. I repeat it again. It's not specific or bound to AI. You have to think of AI as something that allows you to provide, to arrive to better results and to give your clients a better result. And my idea, my view, maybe I might be wrong, but as you said, using AI involves a deeper understanding of how AI works, how the results have to be critically scrutinized. In the end, this is going, in my opinion, to I would say, show that actually you need very good people to do this. So I don't think that it's going to result in a reduction of, for example, jobs. On the contrary, it will lead to the result that you will need better qualified, for example, people doing the legal search, because you want to have people who are able to quickly assess the results of AI and to understand whether this result is good or not. So I would say that this is going to increase the general level. I'm talking about litigation, of course. There might be some areas where, already now you do not require such a high level of skills. But in a job like litigation, in an area like litigation, where you need to have a rather high standard of skills, I'd say that the introduction of AI is going to lead to the result that you will have to have better people working in litigation, people who are more aware of how litigation is traditionally done. Because if you want to use the results of AI in an effective way, you need to be able to really understand the quality and the value of those results. And that means that you need people who are skilled and quick in making this appraisal. I'm fairly confident that in order for, I'm talking now from the perspective of litigation, in order to make the most out of litigation, you will need in the future not only a very good litigator who is going to put all the bits together, but you will need people who will have to help the litigator assess what AI, the output of AI, in order to pick up the best arguments, the best facts. And that's why I think that this is going to lead to, in general, to an increase of quality, even of the workforce, if I'm allowed to use this expression. That's my view.
Yeah, I'd be curious to know what your thoughts are on this. I've in the conversations that I've had, it's like at first it starts maybe as like, okay, well, cost savings, but it's almost always tied to trying to create more efficiency, right? And to open up the door for those already highly skilled litigators that you might already have to actually get out from underneath, whether it's like you have a lean team or whatever the case may be, to focus more on adding value with their skill set. And then all of a sudden there's light bulbs that go off and it's like, well, actually, instead of thinking about this as cost savings, let's first stage one is optimizing and making things more efficient. And then stage two becomes, what can we do with regard to maybe creating, new projects or new revenue streams because we're accessing projects and markets that were previously not possible for us. So is that kind of something that you agree with? You think that that's the mindset? I'm wondering what your thoughts are on that.
I do agree. I do agree on this. And there is one point that is linked to this. I think that since, as I said, being able to use AI effectively and also to open up these new avenues requires people who are smart, who are able to assess those results critically. This might also open up, I would say, the way for smaller, for example, law firms to become able to compete, for example, with big law firms. Because in the past, I'm just thinking again of the example that JP made at the beginning of the soldiers doing the legal research. In the past, if you had a big case, for example, in court, you needed a cohort of people doing the legal research, preparing all the bits of all the documents for the solicitor, for the litigator that goes in court. But if you are now able, by using AI, to arrive at those results more quickly, and I would say also maybe to go more in depth, because as I said when I made the example of the diagnosis of disease, can provide you with good results or better results quickly, then you might not have to have a cohort of soldiers, of people. And this could provide smaller law firms, for example, a chance to compete with larger firms, which in the past could afford the cost of having this army of people doing the legal research. So I think the AI, as I said, it can be, of course, it could produce bad results, but if you think of it positively and if you use it critically, it could even lead to a democratization, I would say, of litigation, of the legal profession, which, as you know, is generally a field where only the big firms, the big players they normally dominate the market. So there are several aspects of AI which can be, in my opinion, positive, but you need to see them and to think of AI as I said, as an augmentation which can be used to enable you to achieve results which were previously not possible, simply because the time required to do this legal research meant that you had to have a huge number of people doing that.
Yeah, it's like time can always be improved, but quality can't.
Yeah.
Quality always needs to remain the same, if not be improved. And I guess what you said is a good sustained objection to my comment. If anything, it could actually expand the workforce, because firms that normally wouldn't be hiring for these roles potentially could be opening up more ability for kind of the next generation litigators to get some experience. It seems like kind of what you're saying is that AI can be there to kind of take care of the chores element of it, not
Yeah.
necessarily taking the job.
I think that's one key aspect, taking away the chores, as you said, doing this kind of. I mean, legal research is never a chore, but it certainly involves a lot of dedication and a lot of time. And if you're able to do that reliably by using a tool that allows you to save time, yeah, I would say that's a key aspect. The example that I mentioned again at the beginning of of AI being used to diagnose a disease which sometimes even a good physician might not be able to identify, could be also an aspect which might be of value. I mean, AI could in some cases give you results that even the good litigator might not be able to identify. Of course, AI is not going to provide you with an argument. That's something that the litigator must devise on the basis of the facts and the case law. But as I said before, with this example of ChatGPT, I think it was finding judgment which was really relevant. Sometimes AI can even surprise you and not only spare chores or save time, but sometimes even giving you a result that you were not aware of. But I think that the overall message is that AI is a tool, is a technological tool, and as any tool, it can be used to achieve improvements in terms of, I would say, efficiency, reduction of the time you need to arrive at the result. But in the end, it's the humans who must be able to use those results and must be able to appraise those results and to put them together into, in the case of litigation, a good story that you want to tell the court to convince them that you are right, that your client is
Yeah, that's the human part is interesting. I mean, this has nothing to do with IP at all. It's a music related thing, but I'm going to bring it into the conversation anyway. It's like there's these guys that I see going out and making like, soul remixes of like popular rock and roll songs, and they're using AI to do that. And they're doing a really good job of creating these really cool versions of these songs that we know, from the way that they normally sound. And I find myself going, well, okay, it's kind of weird because those aren't really real musicians doing that. And it's not, a real person singing it, but the person who decided to try and make that version of it and using AI to take that on, there is something creative to be said for that. So the tool's being used creatively, but it's still, computer generated. So it's like I find myself going back and forth between what my ethical standpoint is on how this stuff is being used. And in this world, perhaps it opens up new ways to be creative as well, because the human is ultimately the one who is deciding, how to use the tool, right? And it's human led. So it's just a different skill set coming out. I think that's an interesting thing to think.
This is a very an interesting remark, and I like it because if you think of it, sometimes, for example, a cover of a famous song sometimes sounds much better or better than the original one. I mean, I think my son once made me listen to a song that was a cover by what's his name, Johnny Cash, I think. But the original song was by someone else. I can't remember his name. And I listened to I forgot the name of the
Was
song.
it
But
9 Inch Nails? Was it Hurt? Maybe.
yeah, Hurt. Hey, I think it was Hurt. Yeah, that's it.
Okay.
Exactly. I listened to the original version, which is very good. But then I listened to Johnny Cash, and honestly, I prefer the Johnny Cash version. I think it's there's more pathos. I don't know how to explain it. So this is an example of something which, if you look at it, that could be seen as a mere reproduction of something which has been actually devised by someone else. So in terms of IP rights, it's not Johnny Cash that wrote that song, but the way he performed it, the way he sings, the pathos and the passion. And I don't know if you've probably videoed the video clip,
Yes.
the whole imagery, this image with Jesus Christ, and then I think there is his wife, and he is pouring wine or spirit. The whole thing gives the song a different taste. It's the same song, but at the same time, it's something different. And I think it's the same with the example that you gave. You can use, let's say, bits and things that are known, which have been already devised by someone else, but the way you put them together, the taste, that special ingredient that you add can change the entire picture and how you perceived it. I don't know if
Yeah, for me, it's Nirvana Unplugged, Man Who Sold the World, significantly better than David Bowie's original.
Yeah,
well, what's wild though is those are still humans doing that though, right? Like, and I think that's the thing, right? But it's also funny for me. I'm sitting here trying to think of a way to apply this to litigation into our world.
I can get. Yeah, sorry.
Well, I was just going to say, I think it's a generational thing. And like we all have kids of different generations. My daughter's 15 months old. Her favorite song right now is Baba Black Sheep or Wheels on the Bus. Like I can't wait for that remix to come out.
But I think we have to. Well, in the end, it's the example that GP made at the beginning. It's the cookies. No, you might use the same ingredients in principle, but the process, the way you assemble things, the way you maybe treat one of the ingredients, and then how you process it during one phase, it can change the final result. Sometimes it's just, it's like this is again an example that comes up to my mind. I read an article. It was an interview with a famous, I'd say, I think it's one of these surgeons that do aesthetics. How do you call them in English? I forgot the way to say it. That change, for example, your nose or do some change unit. Sometimes you can cut or you can change the shape of a nose just a few millimeters. It's just a matter of millimeters, and the final result can be gorgeous or it can be horrendous. So it's the same with sculpture. It's just a matter of details, and I think it's the same with litigation. You can start from the same facts. So facts are facts, I would say, but the way you relate those facts or how you, for example, infer conclusions from the facts, the way you also present those conclusions that you're drawing from the facts can change the outcome of a case. Because in the end, you want to convince humans. This is what litigation is about. It's about, as I said, telling stories to convince the court that your client is right. Even if the facts are the same, assuming that you start from the same set of facts, the way you relate those facts and the way you put together all the bits of information, how you connect the facts, can heavily change the perception. It's the same. It's the example that you mentioned, Carl, about soul music, about that
derived music. We were hearing some of it in Monte Isola, and I could hear. I was with my ear. I was like, that doesn't sound natural.
Yeah.
And I know recently I was working with a company that was discussing the humanization of electronic and AI made music. So, kind of the one thing that makes me think, in a sense, of just how Johnny Cash probably never would have thought of using AI to create music.
Well,
This next generation litigator, and I understand, Dali, that you also do some teaching and you do some work at universities. I'd really like to get your view real quick on kind of what happens with this next generation growing up with AI. Like for us, it's new. For them, it's normal. Like for my daughter, when she's up and running, it's going to be like what a Walkman was for me. So I'm just kind of curious to see your view of this kind of next generation litigator and the impact of AI?
Yeah, well, thank you for this. Is a very good question, because this is, I think, a point where I can see some problems. In general, I'm an upbeat and optimistic person, and I try to see things positively. But this is an area where I could see some trouble. And what I mean is that sometimes for example, lately I've been seeing articles or interviews with teachers saying, well, we let our kids use ChatGPT. We want them to learn how to use ChatGPT. It's not going to prevent them from learning. And I'm not completely happy with this attitude, because I think you need to learn things the hard way. When I say the hard way, it means that you need really to try and, for example, do the maths or try and write an essay without the help of ChatGPT or any or whatever tool, or the help of an adult. It's the same. You want to learn it by trying and doing it. And this is where I see a problem in the field of teaching. Sometimes, for example, with my kids, when they had to prepare to write an essay for school, sometimes they would turn to Wikipedia and start taking whatever they found on Wikipedia and then using it to assemble it in an essay. And I told them, look, this is not the way you should do some research, not limiting yourself to one source. You should take a look at several sources, trying to figure out to make up your mind as to which facts are relevant or important, and then trying to put those facts together and to relate them. And this is where I see a problem. I'm a bit afraid that young people would see the use of AI in general, these, for example, these LLMs as the norm, as something normal, and that they would then give up on doing, for example, their own search, on trying to find the facts, or for example, learning how to identify which source is more reliable or should be used. And this is where I have a problem with this with AI, and where I see I'd say a problem with the young generations. They might grow with the idea that it would be normal to write a prompt to ask AI to provide you with let's say an essay, or with an appraisal, or with whatever you might need. You need to learn how to write, for example, an essay, or how to write an opinion, writing legal opinions, for example, just to go back to my job. You have to learn it, and you learn it, for example, first of all, by reading good judgments, and then by starting to draft your opinion and discussing it with your mentor, with your tutor, or by trying your submissions before a court to see whether they work. So this is probably the only area where I have some reservations about the use of AI. I think AI should be used once you have enough experience, once you know how things work. And at that stage, you might resort to AI, because it can provide you with a draft which you then work on, but on the basis of your expertise and experience, you can refine it, improve it. But I do see a problem in the field of education, relying on, as you said, young generation might be tempted to, well, they probably see AI as you said, very much as a Walkman was for you, something common and normal. They might think, well, using AI is normal. I can't see any other way of writing an essay than by writing a prompt and getting the result and using it. This is something that I see as problematic, and honestly.
I think, I was at a legal event in June, Legal Tech Talk, great event, and some really good panels on very similar subjects of implementation risks. And there was one law firm, just off the top of my head, I remember they were saying that they don't allow anyone below the associate level to use any AI. So anybody in those levels still need to do the nitty gritty work, and then the work is checked or supported by at that kind of next level where the expertise is already present. Which kind of brings us to, that's kind of like a past, present, and future amalgamation into one. Um, but looking into toward the future, and towards kind of like the imagine if, what challenges do we see, in a sense of the risks of let's say, nefarious players who purely use AI to draft a patent, and that makes it through the review process. Because we know the USPTO is offering the opportunity to check patentability using AI. Can you not trick AI with AI? And what impact this is going to have? We were talking about, the IPR and the PTAB thing coming through as well.
Well, there is obviously a risk that some disingenuous, dishonest players might use AI to flood court with submissions which are AI generated, and then to put the burden onto the court or the other parties to litigation proceedings to check whether these submissions are correct. I mean, even nowadays, you know that you can generate submissions by asking one of these LLM models, and then it's up to the court and to the parties to go through these submissions to spot any mistakes, any cases which do not exist. But that takes time. Normally, in litigation, it's quite normal to have submissions that can be, I would say, 100 pages long or even longer. That's not unusual. And if you have to go through such a long submission and to check each and every citation, or to see whether, for example, case law which is cited in support of an argument does exist, then you do have to take your time, and the same applies to the court. So there is a risk that some, as you said, nefarious, disingenuous players might use this to put pressure onto the other parties. It is true that probably in the future, by using AI, you might cross-check. But in the end, as I said, since it's the litigator who takes responsibility for the whole process, and the honest litigator, the good litigator, is going to check himself or herself these submissions, this is going to take time. So there is a risk that AI might be used by, I would say, disingenuous players to their own advantage. I'm confident that in the end, the system will react and will find a balance, and these disingenuous players will get caught. We've already seen this in court, but it puts a burden on the system, because if you can generate in a matter of seconds submissions, whereas I, as an honest litigator, need a couple of days, 3 days, it depends on the case, to prepare, to draft a properly written submission, then this is obviously going to introduce an element of imbalance. And you can't, I mean, there are some suggestions in some jurisdictions to ask litigators to state whether they used AI to generate a result, but that's not going to help much, because in the end, even if you say, okay, I used AI, you still need to go through the submissions to check whether their content is correct or not. So this is a risk that does exist, that puts a burden and a strain on the courts, first of all, because the judge must, in the end, decide himself or herself whether a submission is, for example, correct, whether the cases cited are correct. It requires certainly a cooperation from the other parties that have to be from the opponents or from the counterparts, but it does put a strain on the system. So this is an aspect where I can see at least some trouble and some dangers. Although in general, I think the majority of players in litigation are honest and ingenious. But when there are high sums of money at stake, things can get can go awry. So this is probably an area where I can see some trouble or some dangers. I don't know, Carl, how you see it.
You talked excuse me, a lot about kind of the system that is used to kind of sift through all of this. And I was just in Northern California last week at an event that talked a lot about the USPTO's proposed IPR rule changes, and what the role of the director is going to be. John Squires is the new head of the PTO. Essentially, I mean, I think many listening will probably be familiar with this, but on a high level, they announced two really big changes that could significantly impact how companies challenge patents. The first is that they're proposing new rules for what would ultimately make it much harder to start an IPR if validity is already being handled somewhere else. And then the second is that the USPTO director will now personally decide whether an IPR even gets started, instead of a PTAB judge making that decision.
All right.
So it shakes up the entire system. I mean, what the proposed rule does is, you have to choose one path. It's either PTAB or court, but not both. So filing an IPR becomes kind of a one-way door where you commit fully to the PTAB and give up your backup options in essence. and then you cannot file an IPR if the patent was already upheld somewhere else. So once a patent claim has been upheld anywhere, that door closes for the PTAB. Go ahead, Ollie.
Yeah, well, I think, well, I can understand the rationale behind it. The problem is the backlog. The thing is that courts and the USPTO are probably flooded with cases, with challenges to the validity of patents. And this is the risk that I was talking about. If you use AI disingenuously, in principle, unless there is some kind of rule like the one that you mentioned that the USPTO wants to introduce to put a limit, for example, on the number of attempts of the goals that you can have to challenge the validity. Obviously, if you can use AI to generate submissions in a few seconds and use this just to put a burden onto the patentee because you face him with the multiple challenges, this is of course unfair. And I think that I haven't read in depth about the reasons that brought the USPTO to propose this change. But I can imagine that one of the reasons is that the backlog and the risk that by using AI, this backlog can increase. It's like, the patent trolls. There was a phase. I think that you still have these non-practicing entities.
Exactly.
It's the same. They want to put a burden onto the patentees or the other parties by bringing cases to court, which in the end, unless you are forced to reply, because if you're brought to court, then you have to reply to the allegations that if the other party is using AI in a dishonest, disingenuous way to generate submissions, which you have to go through to understand whether what they're claiming, what they're alleging is correct, this puts a strain. So I can imagine that the reason why the USPTO, as you said, is going to decide whether you are allowed or not to bring this case, is an attempt to put a limit to these attempts to challenge validity. Whether it works, I don't know.
Right, and so I think the practical implications, which is what we're getting into here, companies need to really rethink their litigation strategy, especially the timing of it. And the other thing here too, I think is interesting, is that patent owners will have a much stronger hand, right? Especially if their claims have already been upheld before. It's almost like, well, okay, how is AI going to impact the patent prosecution side? If you're a patent owner and you have something that's been issued and you have a stronger hand in that sense, and that your claims have already been upheld, maybe they've been challenged before. I think that's where some of it shifts. I just think that it's a major policy shift, and if it's implemented, it's going to fundamentally reshape like how and when companies can challenge, right? And I think that is going to obviously lead to a lot of different implications. We're just talking about a few of them, but I wonder what your thoughts are on that.
This, if I may, because this is an interesting point, and as you know, I'm a former patent examiner, and there's been a trend at the USPTO, but also the EPO, where I worked. Patent examiners are under high pressure to grant patents, and I think that this is not necessarily a good thing. Let me explain what I mean. In the past, examiners, both of the USPTO and the EPO, I'm now talking about these two cases because those are the officers that I know best, had enough time to do the examination. And if you do the examination of a patent application too hastily, there is a risk that you grant a patent which will be then challenged and might be found to be invalid. So I think that one of the things that maybe the legislator or the authorities in Europe or in the US should think about is to improve the quality of patent examination, which means performing, for example, a good prior art search to avoid granting something which is too broad or which in the end might fall in court. But this would then require opposition proceedings in Europe or inter partes review proceedings in the USPTO. So what I'm saying is that to reduce the strain on the courts after the patent has been granted, we should probably think, wouldn't it be better to do a better prior art search and a better examination before the application gets to grant? Because that would avoid having then patents which might have to be challenged, because in the end, a patent is a monopoly which encroaches upon the freedom of enterprise and which can then justifiably require a challenge in court. So I can understand what the USPTO is trying to do, but maybe, this is just my thought, maybe the USPTO and DPO should think twice and give examiners more time and better tools to do the search and the examination. This is because I think that there is this, unfortunately, there is nowadays this pressure on examiners to produce. I don't like this word when it comes to examination. I think patents are not products. I don't like this word. And there should be more time for quality examination. And how can you have more time for quality examination? If you can do the search more efficiently with better tools that allow you to retrieve all the relevant documents, then this might spare us then the need to challenge patents in courts. And just one final thought, Carl. I know I talk a lot, but when I'm thinking about the quality of search, why I mention it is that in my experience, for example, nowadays at the EPO, I do a lot of oppositions. It's like the inter partes reviews in the US. I very often find documents, patent documents, which then bring to the invalidity of the patent. And this is something very bizarre because you would normally expect examiners to have found those patent documents. I mean, what normally happens in a position is that maybe you have a prior use. You sold a machine which anticipates the features of a patent, but this machine was obviously not known to the patent examiners because patent examiners only look for patent documents. But if you find very relevant patent documents which kill a granted patent, that's normally a sign that the patent performed by the patent office was not good. And so I think that the USPTO and the EPO should think hard and maybe improve the quality of the patent search and examination, which used to be good, but which nowadays is carried out too hastily, with the result that you end up with patents which are not worth the paper they're written on, and which require a challenge in court or before the PTAB.
I agree completely, and I think as innovation continues to get faster and faster, that becomes even more important.
And I was going to say, ironic, coming from Italy, I think you're preaching to the converted over here, us at IP Rally, about the quality of a good prior art search. And it's also just the quality of the filings, and kind of like to tie a bow around this episode. It really is the importance of when legal intelligence meets artificial intelligence to provide a high quality throughout the process, higher quality filing, higher quality prior art search, higher quality patents. Therefore, if an opposition is filed, it's already gone through a stringent. I think we were looking at some numbers yesterday. It's what 81.6% of patents that go through the opposition process are either changed in some way or completely invalidated, which is
exactly
massive.
I had a look at some figures in Europe, and nowadays you can see a split between what the opposition divisions decide and what the boards of appeal, which is in Europe the judicial instance, a very high proportion of patents get revoked. So this is what I was trying to highlight, and this is what. Sorry if I interrupted you, JP, but that's why I think that the quality of prior art search and the examination is paramount to the good working of the whole system.
Yeah, and we've been thoroughly enjoying our conversation. This is quite possibly one of the longest episodes that we've done, and I think we can talk for another hour.
Oh yeah,
but. To wrap things up, just want to say thank you, Ale, for joining us, and Carl for your always thoughtful input. And we'll just finish it as we do every episode, each of us giving our Imagine If topic. I think for me, my Imagine If, and I'll go back to my recipe, imagine if the ingredients, the chef and the output are human-led, but also supported by AI. What would that do to improve the overall quality of the patenting process? I'd like to hear your Imagine If, Carl, and then we'll finish with you, Ale.
Yeah, there's a lot of different ways I can go with this, but it's almost like imagine if AI didn't just find prior art, but what if it could also help with litigation outcomes and draft arguments and all these changes we're thinking about? Would that make law more fair? Would it make it faster? Would it make it more efficient? I think that, thinking about that is something that comes to mind for me.
Well, I have to say, that's what I was thinking of. Imagine if AI could indeed, augment the ability of the litigator to come up with new strategies, with more efficient strategies. I think that is an interesting area, something that I would like to see in the future. Whether this is going to be possible in the next future, I don't know. But I think that this would be an exciting area. What if AI could help you devise strategies that currently you wouldn't think of? I mean, that would be the next step. But I think that this will take some time before it becomes reality. But it's important. I think that the final message would be that it's important to not to forget that it's the humans, we who are and should be and who are in control of the whole process. And if we manage to keep control of the process, I think that things can only go well. I'm not pessimistic about AI in litigation in whatever area of the human activities. But the man should remain at the center. I come from Italy, the land of Renaissance, and the land where man was put again at the center of history, so to say. And I think we need to go back to this mindset of putting humans at the center of the stage. If we manage to do that, I'm fairly confident that we will be able to do good things while using AI or whatever tools.
Great way to finish. Gentlemen, as always, it's a pleasure. Thank you so much, Alessandro, for taking the time to join us. Carl, thank you so much. And listeners, we'll catch you on the next episode. Thanks again.
Thanks, JP. Thanks, Alessandro. Talk soon.
Thank you very much to both of you. Thank you. Cheers. Bye-bye.